It's been about 3 years since I last spoke on costs to this conference, and it's a very, very different world that we now face. I suspect none of you are going to need telling that. Hopefully, what you will have by the end of tonight is some kind of roadmap setting out what the main changes we know are, when they're going to take effect, and also what we don't know about. So the changes that are in Jackson's report, but that we have very little information to say when they'll be coming into force. You should all have in the pack that you've got in front of you copies of these slides. We're going to move relatively quickly through them. I thought I'd start off with just a few little opinions on the subject of costs. No one's really that interested in the history. Quotation I found from Jeremy Bentham that surprised me a little bit, but it seems back in the 17th century he thought the grandest instrument of mischief in English practice was costs. It certainly seems to be one of the main items of dispute. Since I started at the bar, my costs practice has probably seen me do more trials or contested hearings than my personal injury practice, which perhaps says something about the way in which the system works. I said at the third item on those bulletins, CCFAs and CFAs are lawyers' paradise. There was a period coming up to 2000 in which, long before I was at the bar, a lot of people thought CFAs and CCFAs were going to kill off personal injury litigation, that legal aid was the key to running these cases for claimants, and that the nature of this kind of litigation was simply too uncertain to benefit from a system in which, if you lost, you wouldn't get paid. It hasn't been the reality. In fact, the statistics tend to suggest that the introduction of CFAs substantially increased the level of claims. So there is some unfortunate statistical basis to support the idea of a compensation culture. On the 3rd of November 2008, Anthony Clark announced there was going to be a new review. I suspect most people in this room had barely heard of Lord Justice Jackson before that stage. He certainly became quite well known to the profession after that. It was apparent from the start that this was going to be quite a radical change, and the reason for that is that everything was conducted at breakneck speed. He provided a wide-ranging preliminary report between January and April 2009, so a 4-month window. There was then a consultation between May and July 2009, in which it seemed to those who attended, Lord Justice Jackson turned up, stayed quite silent, made the odd thankful comment at the end and then left. And then he produced a final report between September to December 2009, which in almost every particular reflected the original report put out for consultation in April. So that report's delivered in December 2009. It's on time, perhaps no surprises there. And then a general election took place. And everybody waited with slightly bated breath to see whether or not this report was going to be implemented. There was a suggestion that the coalition might make some form of difference, particularly that the Liberal Democrat part of the coalition might be reluctant to see anything take effect that would reduce the claimant's damages. But in March 2011, Kenneth Clarke announces that the entirety of the proposals will be implemented, and in fact, given the results of Lord Young's report, there was a suggestion initially that a more radical set of proposals might take effect. The strangest feature of Kenneth Clarke's announcement is towards the end of that quotation. It can't be a sensible thing for a defendant to settle a claim, however weak, and get out before legal costs start running up. And the reality is the real problem with conditional fee agreements and CFAs was not the running of hopeless cases that then had to be discontinued, but the overall amount of costs incurred in marginal cases. So cases which had a 55% prospect, which the defendant might very legitimately decide it wanted to take to trial, and which, if it went the claimant's way, would cost a fortune. Strong cases settled early, and therefore didn't incur that much greater a degree of cost liability. Weak cases were siphoned out at an early stage by the solicitor and put straight in the bin. So, a slightly odd reason from Kenneth Clarke in March 2011 for introducing the recommendations, but there is no doubt that those recommendations were welcomed by a coalition government. Very briefly, I don't intend to spend very long on this, the scope of Jackson's report is actually far wider than costs. The remit was quite plainly about costs, but there are a large number of recommendations, particularly in relation to case management, that we know are not going to take effect. He proposed stringent limits on witness statements, stringent limits on the extent of disclosure, a US-style docketing by which cases would be allocated to one judge from the start, and then a two-Lord Justice Court of Appeal made up of the same individuals to decide all appeals against case management. So the intention to reduce the scope of the evidence before the court, to reduce the burden in relation to disclosure, and to provide a consistent approach on appeal. Almost none of that has been put into effect. We know that the Judicial College training guidance does encourage active case management, but then that tends to depend on the personality of the judge that you're in front of. He also suggested major changes to Part 36, which it looks like will be implemented. He wanted a much more automatic consequence. He wanted an end to Carver and the suggestion at the time that he was writing his report that there could be something other than a win if the claimant beat an offer. He also wanted a clearer 10% sanction to be fixed in relation to beating the claimant's offer. It does appear that those consequences will take effect. They are outside the scope of this talk. And finally, most controversially in terms of its implementation, he suggested there should be a 10% increase in general damages as a partial compensation for the introduction of contingency fees. We've already dealt with the government's commitment in relation to what's happening. We then come to when it's going to happen. And the initial very optimistic target was that these measures could be in place by autumn of 2012. And that's obviously not happened. There's a new target date of the 1st of April 2013. Some of the measures we know are already in statute and will take effect on that date. Some of them have already been drafted for the CPR but are not yet available. And some of them have no timetable for implementation whatsoever. The Legal Aid Sentencing and Punishment of Offenders Bill 2012 got the royal assent on the 1st of May 2012 and provides a number of items we're going to have a look at in a moment, but most fundamentally for the removal of after-the-event insurance recovery between the parties and for the removal of a recoverable uplift between the parties. But we're looking at it in a little bit more detail. We know that the CPR amendments have already been drafted, and we know that the Court of Appeal in Simmons and Castle have already attempted, now twice, to give guidance in relation to general damages. Perhaps the best known change is the end to uplifts. I don't intend to read out everything that's on the slide, but the effect of the change is that between the parties, base costs only will be recovered, subject to a contingency fee, replacing the conditional element and being taken out of the claimant's damages. That contingency fee in personal injury litigation is limited to 25%. In general litigation, it's limited to 50%. And the very naive suggestion of Lord Justice Jackson is that there will be some form of competition between providers of legal services, so that the claimant who comes in off the street will hear that one firm of solicitors will take 10% of his damages, the other firm will take 15% of his damages, and the other 5% of his damages. The idea being that everything else being equal, he'll make an informed and rational choice. It's a very unrealistic way to approach personal injury litigation, but it seems to be the thinking behind the rules. By far the most likely occurrence is that some firms will feel obliged, for ethical reasons or for commercial reasons in relation to their union providers, to waive any contingency fee element. And those firms that have a contingency fee element are unlikely to heavily advertise the difference to other providers at the point they sign the client up. When these proposals were first announced to be implemented, the starting question in my mind was, when's this going to take effect from? And it seemed there was a number of options. The first was that it could take effect from the date of accident, in which case the changes would take several years to come through. The next option was that it could take effect from the date of the agreement, in which case there will be a relatively soft landing, but things would move a little bit more quickly. Date of issue, in which case on the 30th of March of next year there would have been an awful lot of badly prepared cases issued very quickly. Or date of trial, in conclusion of the case, which would seem completely arbitrary because it would depend how efficient you happen to have been in getting the case to a conclusion. The answer, which is set out in the Legal Aid Sentencing and Punishment of Offenders Act, is that it will be the date of the agreement in most cases. Now, the Court of Appeal, in its second judgment in Simmons, is very careful to say that it's the parameters of Section 44 that matter, and rejected the Association of British Insurers' suggestion that it should simply be agreements before the 1st of April. It's not quite clear why the court was so careful about that, because in most cases, if the agreement's entered into before the 1st of April, there'll be a recoverable uplift. One-way cost shifting is in principle a measure which ought to favour claimant solicitors, one would think, because it appears to offer a mechanism by which the claimant can bring their claim, the defendant, if it defends it successfully, is excluded from recovering its costs. It's not quite as simple as that, though, because the rule is subject to exceptions in relation to unreasonable conduct and fraud, and it comes at the price of an end to the recoverability of any form of after-the-event legal expense insurance. It's also subject to one much bigger exception in relation to Part 36. So for most quantum cases, the rule will have very little compensation for the loss of after-the-event insurance. Very rare if liability is admitted not to have a Part 36 offer, and at least subject to a cap of total damages, these provisions seem to provide that a failure to beat it will give rise to a costs liability. The provisions in relation to after-the-event premiums are required to be dealt with by way of statute because the original entitlement to recovery was set out in statute. So Section 46 and Section 47 of the Act detail the prohibitions, and they follow the division between premiums that are taken out by a union or some other collective provider and premiums that are taken out in individual cases. There's no great merit in my labouring the distinction. It's set out there on the handout. Effectively, you won't be able to recover the cost of this. And so it will leave claimants entirely unprotected against adverse costs orders, especially exposed in cases where the reasons for unreasonable conduct wouldn't be apparent at an early stage in the litigation. So if we take the example of a claimant whose credibility is heavily damaged by late DVD surveillance evidence, before that date, you won't have a recoverable ATE premium, so you won't take one out. After that date, if you can get cover, and that has to be doubted at that stage, it's going to be a cost that won't be borne by the other side. Relatively significant change. The one item that has no implementation date, and that the Court of Appeal in its judgment on the 10th of October had no idea about a date for implementation, are fixed costs. And I should have said at the top of the handout, it's rather hinted at by the last point, but I should have said at the top, fixed costs are suggested in relation to fast-track cases. The key question, in terms of the economics of these kind of cases, is going to be what level the costs are fixed at. Again, there's no idea of that. The suggestion is that they will be in place by the 1st of April. Now, that suggestion was floated some time ago. I'm certainly unaware of any steps to put them in place by that date. I think we have to wait and watch this space. But the one thing that is inevitable with fixed costs is that it will encourage the cherry picking of cases, because simple, significant injury but fast-track cases that can be swiftly opened, result in damages of £15,000 or £20,000 and settled with very little work, will suddenly become extremely profitable. Complicated, very low-value cases that have lots of issues on liability that need to be addressed will suddenly become very unprofitable. And so there is a significant level of choice and a great degree of risk that people will find themselves unable to get representation in complicated or difficult, low-value, fast-track cases. It's not on these slides, but this is probably the convenient moment to mention the position in relation to small claims track costs. There's been a rather nasty suggestion that the small claims track limit in relation to personal injury claims might rise from £1,000. There's no, again, clear idea on where that limit may go to, although the obvious suspect would be the £5,000 limit that applies in property damages cases. There is no proposal in Jackson for that step to be taken. There is no proposal in terms of a date for that step to be taken. But yesterday, the Ministry of Justice announced that they were still actively considering the measure as part of the package of general reforms, and at the same time announced that the current portal regime in relation to road traffic accidents would be extended up to the full fast-track limit of £25,000. And again, the intention there is to introduce that change by the beginning of April next year. Simmons and Castle is a slightly strange case. It's a case in which there's an appeal in respect of an award of provisional damages, or rather the refusal of an award of provisional damages. The Court of Appeal take the opportunity when that appeal settles to set out what the position is going to be post the 1st of April in respect of damages. And perhaps unsurprisingly, given that Lord Justice Jackson had himself said there should be an across-the-board 10% increase, the Court of Appeal indicated that there would be an across-the-board 10% increase. What's important is that at the date he made his recommendation, Lord Justice Jackson knew that carrying out that increase would inevitably lead to a windfall to certain categories of claimants. Obviously, there are some claimants still, although they may be few and far between, who bring their cases funding them privately, and suddenly their general damages were going to go up by 10%. There'll be those claimants who are acting under an existing CFA, and their damages would also go up by 10%, despite the fact that the uplift would remain recoverable. That didn't trouble him, and he specifically dealt with this by saying, well, we know from Hale and Rankin that significant increases have been made to general damages in the past. The proposed increase is only 10%, and general damages in this country remain very low by international standards. So I say on the handout, any competent counsel advising the claimant after the 10th of July of this year would have advised the claimant of two things in relation to general damages. The first, that there will be a new set of judicial studies guidelines coming out shortly, and the second, if this case was going to trial after April of next year, was that damages would go up by 10%. The Association of British Insurers were very unhappy with this decision. At one level, you can understand the reason for that unhappiness, because they simply hadn't been informed it was going to happen. They had no awareness that the Court of Appeal intended to do it in this way, and therefore, a few weeks after the decision, they applied to be heard on the issue and to have the decision reconsidered. Master of the Rolls refused that application, but listed it to be heard by the full court. Full court heard it, granted the application to revisit the issue, and at the same time did revisit it, setting out a very complicated new scheme after April of next year. The ABI at the time they made the application indicated that the extra cost in cases in which a CFA would remain recoverable, or rather the uplift would remain recoverable, would be in the region of £300 million. There's quite a lot of dispute in the hearing as to whether that figure is correct, but what is absolutely apparent is taken across all insurers, the consequences were significant enough to justify a return. I describe that as a complex muddle. The problem is this. The reality of most general damages assessments is that they take place often in relatively low value cases in front of a district judge who has to approach the question of damages with an element of touch and feel. If the claimant falls into the narrow parameters in which it's no longer possible to get an uplift, the Court of Appeal say, well, your damages should be 10% higher. All those decisions will then be reported in Kemp. If the claimant falls into the category of private funded litigant, rather oddly, the Court of Appeal say you should also get the 10% uplift. But if the claimant, who has a technical responsibility for his own costs, is in fact in the category in which there is a 100% recovery by his solicitors of the uplift, damages should continue to develop in the old-fashioned way. Now, that is, with respect, a dangerous approach to the way in which you assess general damages, because it's going to lead to a great degree of uncertainty. Anybody advising relying on significant value quantum reports after that date will need to know the nature of funding in the case before the judge, which is rather a strange way to approach it. Now, on the last page of the overhead projections slide that you should have in front of you, just a few thoughts when I finished the talk about what I thought the most likely consequences of Jackson would be. And just before I go through those, the main thought that occurred to me when I finished writing this is actually, given the prophecies that have been around, absent fixed costs, which is where we currently stand, the results may not be quite as devastating as they first appeared. The first point is that there will clearly be a substantial reduction in the cost of litigation. However hostile many people in this room may be to Jackson, it is beyond dispute that it will achieve its primary purpose, which is to reduce the amount of money sloshing round, I think Lord Justice Jackson's words, inside personal injury litigation. The second point, which sits alongside it, is there will be a significant reduction in access to justice, especially in complex lower value claims, and I have in mind employers' liability claims as a relatively low value. The firms that will succeed, in my view, will be the ones that can maximise the efficiency of the practices they currently operate and avoid running complex or difficult cases of limited value. And I think we are heading to a time where it may be necessary for some firms to say to client, you do potentially have a good claim. On this basis of remuneration, we're not profitably in a position to run it. Now, it's going to be very difficult for those clients who have union-based links. It may be impossible for those clients who have union-based links, but the other alternative is going to be a significant loss on a large number of cases. Multi-track quantum work will be almost entirely unaffected at the moment, in my view. The reality is that the vast majority of high-value multi-track damages assessments settle. And the second reality is the vast majority of those assessments occur in a road traffic accident context. So an uplift of 12.5% would apply at the moment. That won't be recovered. There will be an increase in early settlement produced by the fear that Part 36 offers will create because of the risk of the claimant paying the other side's costs up to the limit of damages without any insurance. But in terms of the recoverable costs in relation to those claims, save for the fact they'll be brought to an end earlier, they'll remain largely unaffected. Multi-track liability work will be adversely impacted, in my view, to the extent, and only to the extent, that marginal cases are less likely to be taken on. Stronger claims will continue to be commercially viable. There's no question of fixed costs in that context. Fast-track claims, I say, will be significantly less profitable but viable in some circumstances. What we don't know is when there's going to be an implementation of fixed costs, and that's the big question mark that still remains. One outcome, an interesting outcome, may be that there's a return to legal aid days in which cases which have a very poor prospect of success on liability, which will be unlikely to be run on a CFA, may well have a settlement value at an early stage, simply to avoid the defendant insurer incurring the costs of investigating the claim, because they know those costs will become irrecoverable. One additional consequence that isn't on the slide is a possible significant increase in the number of trials. We all know that the 100% uplift is a very significant disincentive to a defendant to take a marginal case to trial. That stick is going to be firmly taken out of the equation, and therefore a defendant which thinks it has a 40% prospect against a claimant's 60% prospect may well be more tempted to run that case to trial than they currently would. And the final option, which is an unfortunate one, is that I think professional negligence claims, which are of course claims in contract, so not personal injury actions, are likely to increase because there will be a much greater early settlement in cases before a final prognosis has been achieved, in cases where there isn't a significant degree of certainty. And in that context, unless very careful advice is given to the claimant, the likelihood is that investigations on a negligence basis are likely to result.